can you hear me?
I can hear you loud and clear. For anybody who wants to, I'm just suggesting they might want to put their speaker view on so that they've got the full view.
Okay, and I can already see some very friendly faces from my past on the screen, which is lovely. Hi Vivian, hi Liz. Yeah, and other people I'm sure aren't there, right? So I'm going to just see if I can share my screen with you, and that should, can you see that now?
Yes.
Can see?
Yes.
Great. Okay, fantastic. It's all working so far. That's good news. Yeah, so thank you very much, Felicity. Thank you very much, Sarah, and thank you, everybody. I just start by saying this is with a general audience. I'm not sure what the level of expertise is across the people who are attending this evening. So my apologies in advance for those of you who are more expert in the law in this area, but I'm trying to pitch it at a level which will be generally accessible. Yeah, so as Felicity said, I'm going to start really with a lecture, which I haven't done for quite a while. So I'm going to talk, and I hope it makes sense, and there'll be an opportunity at the end, I think, to have a few questions, and Felicity, I'm sure, will enliven the proceedings after I've given my talk. I want to start, start by making some general observations. Criminal law, in what we tend to think of as the liberal tradition, takes as its ideal model subject the rational, the cognitively aware, autonomous person. And this is what has been referred to by my former colleague, Professor Nicola Lacey, as the responsible subject of law. And that person, who is a fiction, in effect, for the purposes of this, is a person who is presumptively free to make her own lawful choices and in a quasi-contractual way to determine the limits and scope of interaction with other responsible subjects. And central to that model is the idea or concept of consent. This is most easily explained, I think, in the context we're going to be exploring today with two relatively simple examples. And here I'm drawing on English criminal law. The position in other jurisdictions obviously differs, though in the common law tradition, the variations are typically matters of degree rather than of principle. And there are, of course, numbers, as there always are in law, exceptions, which I'm not going to be mentioning here. In the first example, very simple, these X pushes Y. Technically, this is what we call a conduct and offence, an assault, or even more technically, a battery. And it's a battery because Y's autonomy is violated. Y is presumptively entitled to freedom from X's physical interference. And that pushing is a harm, albeit a trivial one. But if Y consents to X's touching, Y's autonomy has not been interfered with, and there is no harm. Indeed, you could go further and argue in that situation that Y's autonomy, as manifested in her ability and capacity to make a choice as to whether to be touched, has been acknowledged and to some extent celebrated. In this example, X's conduct is lawful, he's done no wrong, and state punishment is obviously unwarranted. In the second example, X pushes Y, same as in the first one, who falls over and breaks his arm. Y would not have fallen or broken their arm, but for X's push. And assuming for the sake of argument that X was aware at the time of the pushing, that the pushing of Y might result in their fall, and that they might suffer some physical harm, and that a broken arm is treated as serious injury, then X has committed an offence defined in terms of its consequence. If, however, Y had consented to the risk of that injury occurring, and it wasn't X's intention to cause it, then in English law, X is entitled in principle to the defence of consent. Just as with the first example, Y may be injured, but he hasn't been harmed in a way that the criminal law will be concerned with. And Y here is entitled to consent to the risk of harm, and X is entitled to rely on that consent as a defence in criminal proceedings. So those are very, very simple situations, simplistic examples, but they capture the fundamental principles which we're going to build on this evening. So let's turn then to situations of this basic kind in which deception or non-disclosure creates an added complication, starting with potential criminal liability associated with HIV transmission and exposure. I'm going to be talking about HIV in this evening. We can talk a little bit more later perhaps about different viruses and different modes of transmission and stuff, but because the case law in this area is primarily around HIV, that's what we're going to concentrate on. And you note I said starting with liability associated with HIV transmission and exposure, and I say associated with on purpose because we're talking about two distinct situations. The first is liability for causing another person to become infected with HIV or attempting unsuccessfully to infect them. And in this case, we are concerned with the relevance of deception as to, or the non-disclosure of, HIV status to liability under offences against the person and attempts legislation. The second is liability or potential liability for sexual offences such as rape, where we are concerned with the relevance of deception and non-disclosure of HIV status to the question of consent to, in that case, sexual penetration. And although these are distinct areas of criminal liability, it will, I hope, become clear why and how these are interrelated, becoming increasingly so, and why this is becoming such a complicated area for the criminal courts. Let's start then with liability for HIV transmission. The specific basis for this depends obviously on the law in the relevant jurisdiction. In England and Wales, for example, allegations of transmission are prosecuted under the Offences Against the Person Act of 1861. Reckless transmission, where the defendant was aware of the risk of transmission and that risk materialised, are prosecuted under Section 20, and intentional transmission is prosecuted under Section 18. And in this jurisdiction, there is no liability merely for exposing someone to the risk of infection, though there is if a deliberate attempt to transmit is proven, and Felicity, I know, will talk about that later. Crucially, following the judgments of Mohammed Dika and Feston Kanzani in the early noughties, there is no criminal liability for recklessly causing serious harm where a person who has acquired HIV consented to the risk of acquiring HIV. However, that consent has to, following Kanzani, have been conscious and willing, and the defendant's belief in consent, where the consent is denied, has to be honest rather than merely reasonable. So how then do deception and non-disclosure operate in these cases of alleged transmission? And the first thing to point out, of course, is that where HIV has been transmitted and there has in fact been consent, it is far less likely that a case will ever reach the investigatory or prosecuting authorities. A person who knows their partner's sexual partner's status is comfortable both with that and the risks associated with certain conduct and the risk of acquisition is hardly going to alert the police where the relationship is going well, which isn't to say, of course, that they may not choose to do so if the relationship ends or if for other reasons they wish to assert that they never knew or they were never told. And we see from the cases that have come before the courts that many of the cases are have come before the courts when the disclosure or the deception or however it's characterized have come to the attention of the complainant as a result of which or associated with that relationship has come to an end and the person feels wronged as a result of the non-disclosure, the deception, and that is one of the motivating features or the reasons for going to the investigatory authorities. The more common case is where someone discovers that they are HIV positive, believes that it was a particular person who is the source of their infection, wasn't aware of their partner's status as a consequence, then the risk associated with engaging, and they weren't aware of the risk associated with engaging in potentially risky intimate physical contact. Now, leaving aside for the moment the complexities scientifically that are involved in determining whether it was in fact the partner who was the source of the infection, which is a whole other area of discussion. A key question concerns the relevance of the partner's failure to disclose their status or their deceit when asked about it. And the simple answer to this question is that such a failure or deceit will prevent the partner from successfully claiming the defence of consent. Although there is in English law no positive duty to disclose, the failure to do so will, in the typical case, be inconsistent with any assertion that there was an honest belief that there was consent, especially where the complainant asserts that they wouldn't have engaged in the activity which carried the risk of transmission if they'd known the truth. And that much is well settled, and the scenario set out is, with some variation, I guess, the standard HIV criminalisation narrative. What is more of a challenge today is the relevance and significance of effective antiretroviral treatment, of ART. Because in the scenario I just outlined, it's important to note that I was concerned with the operation and availability of the defence of consent. And that has to be distinguished from the question of whether or not there is evidence or proof of fault, of recklessness. Those are two distinct matters. And that distinction is really important, because the defence of consent will only be relevant if there's proof of fault in the first place, or evidence of fault in the first place. A defendant who isn't reckless, i.e. one who didn't consciously take an unjustifiable risk of transmitting HIV, doesn't need the defence of consent to avoid liability. Suppose, for example, the defendant knew their HIV positive status, they used a condom according to manufacturer's instructions, and the condom failed, resulting in transmission. It would be open to a jury to conclude that a defendant may have been aware of the risk of transmission, but that the precautions taken to prevent it were objectively reasonable. And interestingly, this is what the Crown Prosecution Service's guidance in England and Wales now reflects. This doesn't mean, of course, this may not be how a jury would in fact evaluate the defendant's behaviour, especially since the evaluation will only arise in the event that the risk in fact materialised and precautions were in fact inadequate and physical harm has in fact been caused. But in principle, it is open to them to determine that there was no recklessness and no fault. And this issue has become even more live, if you like, in the era of effective treatment. Scientific studies have now established beyond question that a person with an undetectable viral load cannot pass on HIV to a sexual partner. U equals U, undetectable equals untransmissible. So what is the relevance of that for our present discussion? Well, we can think of a couple of ways in which it might be, I suppose. The first is that a person with an undetectable viral load will not, because they can't pass on the virus, be criminally liable for a transmission offence. This does not mean, though, and this is very important, that they will not be subject to criminal investigation if an allegation is made. And I don't want to underplay the devastating consequence of this for the person concerned. Criminal convictions, of course, are only a very small subset of investigations and of prosecutions, and the latter are also very serious matters. Even if a person is not in fact charged, or are charged and then not prosecuted, or prosecuted and then dropped, the disruption to their life and the stigma associated with this are very real. And the Terence Higgins Trust and a number of organisations have done some very good exploration around this, and the National AIDS Trust in this country as well. We're very concerned around that. So the criminalisation in principle in trial is one thing. It's a very small subset of a broader issue, which is why people are concerned about criminalisation as much as anything else. Second point is that in jurisdictions where exposure liability exists, or where, as in Canada, for example, mere non-disclosure of status can convert otherwise consensual sexual activity into an assault or an aggravated sexual assault, the question arises as to whether disclosure of HIV status per se is something that should be expected or required. The reason for this is that for those who are undetectable, the disclosure of status does not, arguably, provide any materially relevant information for a sexual partner. Put another way, because there is no risk of physical harm, And because there is therefore no interference with or violation of the partner's autonomy as far as physical integrity, if you like, is concerned, there's no justification for criminalisation. Just going to move on to the next slide. And this leads me on to the second area of criminal liability associated with non-disclosure that I mentioned at the beginning, where it results potentially not in the commission of an offence against the person, but in the commission of a sexual offence. And I will just start this bit by, and I think I'm going to look at Felicity's face and she might smile, it's just a terrible, terrible mess, right? Basically, we're now entering into a really, really messy area. Here, the question of whether or not HIV is in fact or could be transmitted is essentially irrelevant, because we're not talking about the actual or potential causing of physical harm. Rather, we're talking about whether the mere fact of HIV non-disclosure renders otherwise consensual sexual activity non-consensual and therefore unlawful. And that in turn requires us to determine whether the fact of a person's HIV status per se is sufficiently material to the question of whether a potential complainant's consent was willing and conscious. And as far as England and Wales is concerned, for the time being at least, the law appears to be clear. So it appears to be, it'll be obvious why it's become less clear. Failure to disclose HIV status does not convert otherwise consensual sexual intercourse into rape. In the case of the Crown against EB in 2006, the Court of Appeal had to consider whether an undisclosed HIV status could vitiate consent, and the court ruled that it didn't. The act of sexual intercourse remained consensual. In the case of EB, there had been no active deception as the complainant had not asked the question. And the court stated, these are very important, these nuances become very important. The court stated categorically there, and I've put the quotation on the presentation, where one party to sexual activity has a sexually transmissible disease, so we're not just talking about HIV, which is not disclosed to the other party, any consent that may have been given to that activity by the other party is not thereby vitiated. The act remains a consensual act. However, the party suffering from the sexual transmissible disease will not have any defence to any charge which may result from harm created by that sexual activity merely by virtue of the consent. That's going back to the OAP issues, because such consent did not include consent to infection by the disease. Now, that looks relatively clear, but things are becoming increasingly muddied, and the muddying turns on the difference between failure to disclose, active deception, and what is known as conditional consent. Moving on to the next slide. So, in the case of Julian Assange and the Swedish Prosecution Authority, the administrative court stated that consent could be vitiated under Section 74 of the Sexual Offences Act, which is the section relating to what we mean by consent, if a person positively misled another as to their intention to wear a condom during intercourse. And Section 74 states that, and I quote, a person consents if he agrees by choice and has the freedom and capacity to make that choice. And in the case of R on the application of F against the DBP in 2013, the court held that where a man knew that his wife's consent to penetration was dependent on ejaculation not taking place internally, and knowing this, he, quote, deliberately ignored the basis of her consent to penetration, there would be no consent. And in this case, what was critical was that the husband had ignored his wife's clearly articulated limitation to consent, and at the time knew that she would not have consented had she known of his intention to ejaculate prior to withdrawal. Now, these cases need to be read against those concerning so-called gender fraud. And what we're talking about there, of course, are cases in which a complainant believed that the person with whom they were engaging in sexual activity was a different biological sex from the one the defendant presented with. So, for example, in the case of McNally, the appellant, McNally, pleaded guilty to 6 counts of assault by penetration, contrary to Section 2 of the Sexual Offences Act. The reason it was assault by penetration is they prosecuted under, excuse me, digital penetration, which fell under that. Sorry, I just have some water. The prosecution case there was that, contrary to the appellant's assertion, the complainant had believed that the appellant was male, whereas in fact she was biologically female. On appeal, McNally argued that the complainant had been deceived only as to the gender, and that deception as to gender cannot vitiate consent, in the same way that deceptions as to HIV status, as in the case of EB, do not vitiate consent. And the Court of Appeal in that case disagreed. It held that EB, remember that's the HIV non-disclosure case, held that EB did not say that HIV status was never relevant to consent, and that the situation might be different if the complainant had received explicit confirmation, if you like, before intercourse that the defendant was not HIV positive. It held that a common sense view should be taken as to what kinds of deception may vitiate consent. So put summarily, where a person's freedom to choose, if you like, whether or not to engage in a sexual encounter is removed, as it was in the Court of Appeal's view in McNally's case, then there is no consent and the offence is established. Now, the case law in this area, if you're not confused already, then fantastic, because it's very difficult to align these cases very, very easily. The case law has been made even more confusing as a result of the decision of Lawrance last year. And here, and it's those of us who've taught criminal law used to use this example as a hypothetical in criminal law problem questions for our students. And then you find that a case actually appears in the case law. And here, the appellant had lied to his female partner about having had a vasectomy and only told the truth after having had unprotected sexual intercourse with her, as the result of which she had become pregnant. Lawrance appealed his conviction for rape, and in a judgment that is not, and I think the phrase is with respect, a model of clarity, the Court of Appeal held that the appellant's deception did not deprive the victim of their freedom or capacity to choose to have sex with him, which is, as I hope you understand, rather difficult to square with the narrative in Assange and in McNally. It's very difficult to square the decision of Lawrance with Assange and McNally. The Court of Appeal held that the distinction lay in the fact that the complainant here, in Lawrance, agreed to have sex without, quote unquote, any physical restrictions. Right? So in other words, that was the kind of Assange thing, and without deception as to the physical performance of the intercourse itself. So the determinative question was whether the deceit was, and I quote, sufficiently closely connected to the performance of the sexual act rather than what they referred to as the broad circumstances surrounding it. And it also disapproved of comments made in the court by McNally, by the court, that a distinction should be drawn between passively withholding relevant information, i.e. failing to mention HIV status, and actively lying, for example, stating that one is HIV negative when asked. The Court of Appeal indicated that deception was a spectrum and that there was no bright line between active and passive deceit. So, where does this leave us? On the face of it, there are, and this is an arguable point and has been argued by some, sound reasons. I'm not presenting my own views, I'm presenting a range of views here. Sound reasons to criminalise those who culpably infect or who are ostensibly willing to risk infecting others with HIV. This is a common sense view, reflecting a lot of popular media representations, of course, and elsewhere. And they centre on the harmful impact of the disease on individuals and populations and the need to deter risk-taking behaviour in the interests of public health. However, legal scholars, clinicians, virologists, epidemiologists, along with civil society and incredibly well expert-ridden international organisations have long advocated against what they see as the unjust and ineffective use of the criminal law in this area. Although there is widespread, well, there's consensus at least, I mean, there are obviously differences of opinion here, among anti-criminalisation advocates, that while the most egregious and most morally, if you like, blameworthy conduct, deliberately, purposefully infecting another person with HIV, whether it's a deliberate attempt to use HIV to harm another person, and that's categoric, then that, and only in that situation, is there any argument for criminalisation, and that's the only justifiable circumstance. And that's the conclusion of the Global Commission on HIV and the Law, of UNAIDS and others. That doesn't mean that there aren't problems with intentional transmission, and what we mean by intentional transmission and how intention is constructed in criminal law for the purposes of criminalisation. And I know that this is something that Felicity is going to return to when she speaks. I'm really interested to hear what she has to say there. And the reasons why all other cases don't justify the use of the criminal law, so here we're talking about exposure, we're talking about reckless transmission, could be summarised as follows. The first one, very importantly, is there's scant evidence that criminalisation is effective on public health grounds as a general or individual deterrent against practising unsafe sex, and some growing evidence that it is ineffective and counterproductive. A significant proportion of new HIV infections result from sexual activity between those who were previously negative and those who are positive but undiagnosed and therefore not on treatment and potentially more infectious. Because criminal liability generally only applies to those who know their status and can therefore be held morally responsible, they know their status, they're aware of the risk associated with their conduct, it's incapable of being an effective prevention tool against transmission in this context. Secondly, overly broad criminalisation reinforces negative stereotypes about people living with HIV and AIDS through frequently inaccurate and sensationalist press coverage of trials and convictions. We know that although Rowe is the first person to have been convicted of intentionally transmitting HIV, that doesn't mean that we haven't had for decades now press coverage which said, referring to reckless transmission cases as deliberate transmission. And that is something which is repeated again and again. And this contributes to the stigma associated with HIV, which in turn creates obstacles to prevention and treatment and undermines the right of people living with HIV and with AIDS to the highest attainable standard of physical and mental health and well-being. Thirdly, there are countless examples of cases in which the criminal law has been used, even where the defendant took reasonable precautions and where there was no transmission or where there was no risk of infection, to impose extremely harsh sanctions, and cases where police, prosecutors, prosecuting lawyers and courts have failed to understand, and in some cases, it has to be said in the early cases, defence lawyers failing to understand the scientific evidence adduced to support allegations of and convictions for transmission. And when we put up the notes to this, we'll have some references, which will include a reference to the global expert consensus statement that was released at the last World AIDS Conference in Amsterdam in 2018, where there was Françoise Barré-Senoussi and other really high-profile clinicians and scientist researchers really question the validity, the reliability and purpose of using criminalisation and evidence in criminal cases because of the problems associated with it. And there is significant evidence building up that criminalisation disproportionately impacts on women. It impacts disproportionately on people from minority ethnic communities and those from socially marginalised groups, and is discriminatory in its application. So finally, in an era of effective treatment where this is available and accessible, that's a very important point, there looms the prospect of criminal liability for serious sexual offences where a person living with HIV is undetectable and presents no risk to their partner, but fails to disclose their status or potentially even chooses to withhold it when asked. And we have no real clarity from the Court of Appeal on what constitutes deception for the purposes of determining the parameters of consent, which is essential and central to these offences. All we've been told is that it's a slippery concept, that it exists on a continuum and presumably will turn on the facts of the particular case, which provides little, if any, comfort to anyone. And that's all I'm going to say. So thank you very much, Felicity. Over to you.
Thank you, Matthew. Thank you for dealing in something so complicated so quickly and in the exact amount of time. Brilliant. So I'm not going to give you any slides, those of you who are listening and watching, but I'm going to pick up on 5 topics. Really what I think is the nonsense of the Court of Appeal language of common sense or sufficiency. Can you still hear me? I feel I've lost you.
I can hear you.
Oh, good. Sorry, something happened on my computer. So
I just took my presentation down.
Oh, brilliant. Okay, I'll keep going. So first of all, the nonsense, that's the language of the Court of Appeal. They refer to common sense or sufficiency. Secondly, the inconsistencies on impersonation, when people impersonate others or another biological gender. The important distinction regarding viruses as a consequence rather than conduct. What I think is the over-defining of the level of harm that flows from a virus. And obviously I'll mention COVID-19 as I go along. And then, of course, overall, the old-fashioned approach to gender and promiscuity. So what we're really thinking about in this context, I'll give a canter through what is largely a practitioner's perspective, is what laws are necessary. Do these laws or measures correspond to a pressing social need? Do we actually need to regulate the transmission of HIV? And obviously, my view is pretty obvious, which is decriminalisation is where we should be looking in terms of viruses altogether. But we're working against a historic background of regulating sex and regulating the way people have sex. I'm sort of slightly delighted that Matthew used the word slippery, because it amuses my mind to think of all the slippery ways in which people have sex. And we come from a history of where that was regulated. It's somehow criminal to do it in a particular way. So we can really see in this context how slow the law is to recognise the wonderful myriad of people and humans in the world, and preferring to regulate sexual relationships in a relatively draconian way, in my opinion. And we also regulate the levels of violence to which people consent, obviously, and we can talk a little bit, think about that in context of branding and BDSM type cases. And we can understand the regulation of non-consensual sexual relationships, and we can understand the regulation of violence and the cause of harm in those contexts. But does the regulation of the transmission of a virus really correspond to a pressing social need in 2021? And to use that awful expression, going forward, when what we're really thinking about here is deception in public health. And when we're questioning whether a measure is proportionate, what's the legitimate aim being pursued here? Does it relate to consent or deception or consequences? And one question that arises is, if we're going to criminalise the transmission of a virus, do we criminalise the transmission of a sperm, a non-consensual sperm, so that there is harm in relation to pregnancy, which I consider at least arguable, and many may not. And my favourite quote in this context, which was actually in the course of a joint enterprise case that I tend to daily mention, is from Lady Hale, who said, "One man's common sense is another man's idiocy." So as I canter through what I want to say from a practitioner's perspective today, I think if we bear that in mind, one man's common sense is another man's idiocy, it really does deal with the mess that is viruses and the criminal law. So in the context of sexual offending, we of course have section 74 of the Sexual Offences Act 2003, which defines consent as the situation where the other party agrees by choice and has the freedom and capacity to make that choice. And there is deception which can vitiate consent, but what does agree by choice mean? The Court of Appeal have approached this as, well, common sense or sufficiency. They've not yet discussed clearly issues of informed consent or autonomous consent, informed consent or conditional choices. And it's unfortunate, to put it lightly, that this language of information and conditional choices is not what the Court of Appeal have engaged in, because of course not all deceptions will vitiate consent. And freedom and capacity puts the focus on the complainant, on whether they have a mental health problem or they're intoxicated. And so we can think about cases, again, I'm going to canter through it pretty quickly. Lineker, quite some time ago, 1995, where the defendant offered £25 for sex and then he didn't pay. Apparently that wasn't a deception that went to the nature or purpose of the act, but it was labelled a secondary motive for the agreement. Well, I suspect the sex worker would suggest she didn't agree by choice. In F, the case that we've had referred to, the husband agreeing to withdraw before ejaculation and then intentionally didn't, knowing that she didn't consent, was approached in a, quote, common sense way. In Monica, that was a really interesting challenge to the decision not to prosecute an undercover police officer, that the false identity was said to be not closely connected to the performance of the sexual act or intrinsically so fundamental owing to that connection. Just bear with me a second. Because here we go. So Monica, again, it was treated, whether or not that could be treated as a case of impersonation. Did that person really agree by choice when they were having sex with someone who had completely hidden their identity? Again, the Court of Appeal referred to common sense. In McNally that we've heard about, the question there was, is it a deception that was sufficiently fundamental to vitiate consent? Well, what does sufficiency mean? And in Lawrance with an A, the lies about a vasectomy, the Court of Appeal quashed the conviction of rape and said that the condition related to the risks or consequences associated with a sexual act, and it was insufficient to make the deception legally relevant to the issue of consent. So what's sufficient and what's not sufficient, and what's common sense and what's not common sense, it is really not clear at all. It is a mess. The Court of Appeal doesn't appear to intend to engage in questions of informed or conditional consent. It focuses on nebulous common sense or sufficiency. It's taking a case-by-case approach, which really allows for inhibited freedom of choice. But then what is considered to be legally relevant? Where do we identify what's sufficient and what's not sufficient? What's common sense, what's not common sense? And they get themselves tied in knots because they're trying to differentiate, I think, between sections 76 and 74. And section 76 allows for those conclusive presumptions. So you're conclusively guilty, if you like, you're conclusively presumed in context of intentional deception or intentionally inducing a complainant to consent by impersonation. Now, impersonation's an odd one because it has to be in the impersonation of a person known personally to the complainant. There's no need for a pre-existing sexual relationship. So whether a person might personally know someone, it, for example, is not clear. What about if they're in an online relationship? Obviously, it has to induce consent, but it doesn't include a celebrity, for example. So if you think you've had sex with, let's use George Michael for a hilarious example, obviously you can't have done, but that wouldn't count anyway because they've completely deceived you as to who they are. So what do we mean by impersonating someone who's known personally to the complainant? At what point is that drawn? How are we going to have helpful jurisprudence if it's just effectively the opinion of the Court of Appeal on a case-by-case basis? And is it conclusive if impersonation of someone the complainant knows, but they're not deceived as to the identity of the person that they know? And what about gender? So if we compare and contrast the case involving the undercover police officer and McNally, really the only difference is whether or not it's a penis, because the deception is equally egregious. And that seems to be the approach of the Court of Appeal. If there's no deception as to it being a penis, then there's no deception, which is somewhat unfortunate. And intention as to the nature and purpose of the act seems to have returned through all those cases, Devonald and Jeter and Assange and Bingham and Lawrance, to those pre-2003 cases that frankly, people used to laugh at, you know, the idea that the act of intercourse was a singing exercise or a surgical procedure or a medical examination. So section 76 there seems to have been limited to such an extent through that canter through deceptions online in Devonald and deceptions through organised criminal fantasies, back to deceptions as to the nature of purpose of the act, as to whether or not the act of intercourse was in fact an act of intercourse with a penis. So it's all very unclear and comes back to Lawrance, where the decision was the act, whether or not the act was sufficient or insufficient, rather than really whether or not there was an agreement by choice. And all of these cases feed into this approach, this sort of nebulous approach to deception when it relates to the consequence of transmitting a virus. And the failure to disclose HIV or the lies around HIV has been categorically linked to the issue of consent to sexual intercourse or the issue of consent in violence. So treating, if you like, the transmission of HIV in the same way as stabbing someone or in the same way as raping someone, which in my view has created a very draconian approach to the transmission of HIV. And what the Court of Appeal said in Lawrance, the same Lawrance with an A, was that although obiter, they said that even intentional deception about HIV positive status would not vitiate consent. But of course, we contrast that with the case of Rowe that I defended, where it was said that there was intentional infection with HIV, and that would be a Section 18 offence, obviously, rather than a rape. It doesn't make anybody involved in those acts of intercourse feel any different, but it creates an enormous amount of stigma to equate the transmission of a virus to these types of consent cases where there is physical conduct. And in my view, there's an effort in the case of Lawrance to separate conduct offences from consequence offences, but there is still this terrible focus on HIV as somehow part of the conduct, which I think is a real risk for many people living with any virus that is capable of transmission, and probably something we have to be really worried about in terms of the context of COVID-19. As we reach a point where there is vaccination, as we've reached a point with HIV where people can be UU in terms of treatment, when we get to a point where lots of people are vaccinated from COVID-19, are we going to have deception type cases where people say they've been vaccinated where they haven't, or say they've had COVID-19, they've got the antibodies and they haven't? And are we going to see Section 18, Section 20 prosecutions for those types of offences when someone catches COVID-19 or indeed some other virus that rears its ugly head for the next pandemic or localised infection? So I just wanted to talk lastly about some of the problems that arose from the case of Rowe that I defended, because should we really be charging consequences at all following Lawrance if it's not that type of deception? If it doesn't go to deception as to the conduct, should we really be charging anybody? Given the many messy, slippery ways in which people have sexual intercourse, from chemsex parties in the dark to old-fashioned methods, should we be really charging the transmission of a virus at all? Doesn't it potentially over-criminalise the whole of the general public? Does it really make the law certain and clear at all? When is it going to be sufficiently criminal for the state to intervene in the passage of a virus? And which viruses are we going to choose? Having worked so hard to find treatment for the two viruses we're talking about today, HIV and COVID-19, why on earth would we then want to criminalise the transmission of those viruses rather than engage in treatment and public health responses? How are these decisions being made to prosecute what are labelled intentional acts, particularly where there's a dispute that it was an intentional act? When is it in the public interest to prosecute at all? And what if someone says, well, actually, I didn't intend it? Do we really want to be engaging in trials where we ask judges or juries to decide on whether or not that was an intentional act, which is exactly what happened in Rowe? And of course, there's a very fine distinction between deliberately infecting someone with a disease, particularly where the chance of infection is low, as it is with HIV, and then taking a risk that you could infect someone. What is that distinction? We asked in the appeal in Darryl Rowe's case to say, well, surely we should at least direct a jury as to what intention is not, try and differentiate between risk and purpose, but that was rejected. And isn't there a threat here of prosecuting people for deliberately transmitting the virus that can add to people's fears about that virus? And people being worried about the legal implications. They might delay discussion about their health or treatment. There was quite a nice statement in Australia in the Zabaroni case that we did raise in Darryl Rowe's appeal, where they stated a person's awareness of the risk that his or her conduct may result in harm does not support the inference that the person intended to produce the harm. So there was a decision that it was reckless and not intentional. Is that common sense? Is that the common sense that the Court of Appeal would engage in? Well, we gave them at Zabaroni and Rowe, and the appeal was rejected. The idea of at least directing on the difference between risk and purpose in an HIV case was not adopted by the Court of Appeal. And other questions were also rejected in the Rowe appeal. So not just thinking about the distinction between public health and crime, but we raised the decision-making of the Court of Appeal in human trafficking cases. There, the Court of Appeal will apply a policy. Had this been known, this person would not have been prosecuted. So you can see some strong policy indications there in the Court of Appeal. So what we raised was, well, look, there's a strong policy not to criminalise the transmission of HIV. So maybe we should be thinking about a different way of approaching these transmission type cases. But that was wholeheartedly rejected as a totally different type of circumstance. So the Court of Appeal wasn't prepared to engage in any policy arguments about non-prosecution in the context of HIV, even though the Court of Appeal has been very engaged in policy arguments in the context of human trafficking. Even more worryingly, in the Darryl Rowe case, the prosecution used his promiscuity as evidence of intention, even though there was evidence that he was otherwise trying to control his infectiousness through alternative remedies. I'm going to have to put my teeth in. Sorry, I had the dentist yesterday. So what they said was, well, he had a lot of sex with a lot of people, therefore he must have been intending to infect a lot of people. Put that together with the other evidence and he's guilty. Now, I felt that it was frankly appalling to use promiscuity as evidence of intention. Add to that he was trying to control his infectiousness through alternative remedies, that was ridiculed, that he was trying to use alternative remedies rather than taking the proper medicine. And also, more importantly, perhaps, what promiscuity meant was he was actually having limited contact with sexual partners rather than being in long-term relationships, meaning that there was less regular contact and thus less chance of transmission, when we know that transmission is generally not inevitable. So Here you have a prosecution that is prosecuting someone for intentionally infecting people and relying on his promiscuity that actually is evidence that he's not intentionally seeking to infect people, in the context of other evidence when he was maybe not making the best choices, but trying to control his infectiousness through alternative remedies. Not the best public health choices, not the best personal health choices, perhaps, but not evidence of intention. So you're leaving cases to decide, well, is that enough evidence of intention or not enough evidence of intention? And adding to that, the deception in relation to his being diagnosed. He didn't tell people. There was evidence that they asked if he was clean and he said he wasn't. But goodness me, how many times does that happen? I'm not suggesting it wasn't a case that had its problems, its moral problems, but where we have cases where there's no defence, where other people voluntarily assume risk, we could start to think about, well, is asking if somebody clean enough? If we think about those deception cases in the context of rape, there might be one answer. If we think about it in the context of a consequence, in my view, there could easily be another. So if the court is going to focus on deceptions in relation to the nature and the purpose of the act in cases involving sexual offending, what they probably need to do is not focus on that when thinking about the transmission of viruses, where people in life do take lots of risks, including everybody involved in that sexual encounter, which in some cases might involve lots of people at the same time. And obviously there was a lot of evidence of inferences from text messages, and I have a particular concern about the use of text messages to prove intention at all. We all put all sorts of rubbish in text messages. Certainly Mr. Rowe said he used his language as a weapon, but of course the television programme suggested that he had used HIV as a weapon in terms of transmission. So the labelling, in my view, combined with the life sentence for Mr. Rowe, creates a real risk that he is some form of biblical leper, and he won't be alone if we don't deal with these theories and these approaches to criminal law in relation to viruses as consequences, as public health issues. I think there's a very big difference between an alleged intention to infect using promiscuous sex than there is for example, stabbing someone with a hypodermic needle. And it may be we have to move away from consequence offences in sex altogether. And obviously we have to recognise the distinction between relationships and promiscuity. And thinking now about anyone who doesn't maintain an appropriate social distance, could that create a risk of infection and thus a risk for prosecution? I think really what I want to do is, in raising all of that, is just to ask all of those questions that you have to think about when you're prosecuting or defending cases that involve the transmission of a virus. You walk into a trial where, certainly with HIV, it is defined as really serious harm, which I find unfathomable since it's a treatable illness. And I walked into that particular trial on I think the day or within days of California turning it from a felony to a misdemeanor. So it really showed the differences in the approach in the UK and California. So I'm not going to give you any answers. I don't think Matthew gave you any answers, but I agree. The area of law in relation to consent in sexual offences and the transmission of viruses in violent offences, offences against the person, are both a total mess and appear to be based on the common sense of the current occupants of the Court of Appeal that don't necessarily have the same common sense as I do. So I'll leave you with Lady Hale's quote once again: one man's common sense is another man's idiocy. I've rattled on a little bit longer than I wanted to. I had hoped to give you time for questions and answers. I don't know about Matthew's availability, but I'm happy to stay a bit longer if anybody has any questions or answers, questions to ask us.
I've got about 10 minutes.
Okay, so if anyone has any questions, you're welcome to use the emojis to put your hands up, and I'll go on gallery view so that I can see you, or pop something in the chat. I can't see any hands up. I'm just scrolling through. It's lovely to have so many of you and so many people interested in this area. I think what I
know that there are people on this call who've definitely got questions, or at least comments, actually.
I think there is a hand up, Felicity.
Oh, a hand, yes.
Yeah,
oh, okay. So we've got Mark Joseph Rapper. Can we hear you, Mark?
Can you hear me now?
Yes, I can.
I'm not expected to be the first one to ask the question. First of all, really love the presentations. I come from a complete different jurisdiction. I come from Malta, so our approach towards criminal law and how criminalization of HIV is perceived is completely different, the way it is approached. I've got a question regarding a defense. If we are now also have PrEP, pre-exposure prophylaxis, where a person can take it upon himself to protect himself even more than using condoms, or that this you would envision, either Matthew or even you, Felicity, whether you could envision that someone in the defense would raise that the other person had the responsibility to take a pre-exposure prophylaxis, for example.
Matthew, do you want to take that one first? Does PrEP make a difference to what we've said?
We're talking about post-exposure.
PrEP is the isn't it?
I couldn't hear whether you heard PEP or PrEP.
Sorry, it said PrEP. So PrEP, for those who may not be aware, PrEP that you can take in preparation, if you like.
Yes, yeah, absolutely. Yeah, it's a very interesting area, because I'm conscious of the fact, Mark, that we need to think about the real world in these situations, and try and think about, rather than starting, as I do sometimes and criminal lawyers do, from the hypothetical, and then come up with some kind of defensible legal kind of position, which is clever but completely unrealistic, and thinking about the situation where, when we're talking about somebody who, for example, has as it were, says that they have taken PrEP, right? Let's imagine, as a result of which, let's just imagine they have the kind of sex which would otherwise carry the risk of acquiring HIV. The other person, let's imagine that they are a person who has the capacity to transmit HIV to that person and isn't on treatment and is detectable. And the person lies about hasn't actually taken PrEP. It would be almost impossible for me to imagine, other than the usual evidential problems of the he said, or he said, she said problem. I mean, who told people what at what time? And this is why capturing things in digital form, sometimes these conversations can be quite beneficial as well as problematic in terms of evidence, which you might want to talk about, is what is it that the person would have done wrong? They wouldn't arguably have not been reckless, arguably, because they wouldn't have taken an unjustifiable risk. They were aware of something, they made a decision. At the same time, if it ever got to court or to a prosecuting authority, the moral evaluation is always of the person who is the abnormal person, and the abnormal person is the person living with the virus. And that is the person who will be judged to have had the responsibility for minimizing the risk of onward transmission. It might be that you have a member of the police, or you get good advice. They call up THT or National AIDS Trust or a national HIV organisation, which kind of manages to push the prosecution back in a case like that. But we do know of cases where the decision to stop any prosecution or investigation only happened very late on in the process there. And obviously, in cases of exposure, there's an interesting intellectual question about whether somebody does in fact expose someone to the risk of acquisition when they themselves are infectious, but the other person is protecting themselves. And we know that, although we know that it's very, very effective PrEP, it's not, as far as I know, unless I'm prepared to be corrected, it's not the same as you equals you, right? So we're not talking
it's
about
the same. It's over 99% effective.
Yes, that's okay. Yes, well,
I wonder if I might just chip in with one thing here, which is, first of all, I think it's really great that we've got more than one person from other jurisdictions. We chose to focus on England and Wales, but it's great to have you here, Mark, from another jurisdiction, because I think the more we grapple with this, the more, for those, I don't know about Malta particularly, but if there are other countries that are not grappling with it in the way that we are, then we can help in that global movement not to stigmatise people who carry viruses. I think that's really important if we think about it all the time and keep this on the go. In terms of very specific advice as to whether PrEP would stop you being prosecuted, it's almost impossible to say. And the reason I say that is because the Darryl Rowe case, he was prosecuted for some attempts, for attempting to infect people, even though he didn't. So there are going to be some prosecution decisions, depending on what all the evidence is, where some prosecutors are going to decide to test whether or not the allegations are truthful. And what we really see in this context is two things. One is we're keeping HIV as a consequence and over in offences against the person, so that not everybody with HIV is prosecuted for rape, which arguably is a good thing. We're separating conduct from consequences, so we're not accusing everybody who carries a virus of being a sexual offender, so that's arguably a good thing. But then the reality is that we're still criminalising the carriage of a virus altogether, which means that somebody else is making a decision about whether or not there should be a prosecution, which of course my view is no. But in the context that you're raising, we can never say that no one would be prosecuted, because the Rowe case tells us people have been prosecuted for an attempt.
Yeah, I mean, and of course, in some jurisdictions like our own, Mark, you can be criminalised for the commission attempting to commit an offence, the commission of which is in fact impossible.
Impossible, yeah,
so
absolutely.
Impossibility is no defence to an attempt allegation in law, and so you know that raises a whole other issue.
I'm just going to make a comment because I want to people
and
as well.
I've got someone else.
Because from my research, because I had studied at the Maltese law, which deals with transmission of HIV, which is based on the Italian law, because we are continental jurisdiction, so different than you guys. It's a really interesting comparison, because when I try to compare the two, Malta and Italy against the UK, it's a complete different. The UK goes towards the consent approach, which we do not. We focus on the reasonable man approach. And it's a very interesting, so going forward, if you'd want to work on this, I can have the different jurisdictions. It would be really interesting, because it's a complete different scenario and the way we attack things.
Yeah, well, Matthew was on the Global Commission for HIV and the law, so I know there were a lot of people that contributed to the Global Commission, but I'll perhaps chip in and just give you another example that's quite interesting that I like to tell in this context. When we're thinking about deceptions like the undercover police officer deception, which is slightly different, but I was sat in a nail bar having my own nails done, and two young women back in 2003, one says to the other, "Have you heard about this new law on consent?" And the other one said, "No, what does it say?" And the first one said, "Well, it says you have to take reasonable steps to ensure that there's consent." So my ears pricked up. I thought, goodness me, she's got the right wording. She said, "Yeah, we had a lecture about it at college today." "Oh," says the other one, "then what?" She said, "Well, my brother went out and got to a nightclub and got 23 signatures." And so humans are brilliant at undermining these tight regulations that we have in relation to sexual behaviour, because that was totally silly. It was lovely that they'd understood the law. The brother had understood it. He'd gone out, and we're currently talking about text messaging, contents of text messaging. There's even a suggestion of an app where you can agree, apparently without coercive control, to sex on an application. That is just a nonsense, because people will say and do lots of things. And unless we have clear jurisprudence for us to understand clearly where the law begins and ends, then human beings remain messy and are at risk of being prosecuted for something they didn't actually do or intend, that can even be impossible. And that is my serious concern. And however hard prosecutors try, if there's no clear jurisprudence from the senior courts, then we're going to get bad decision making. So Mark, thank you for your contribution. I'm going to keep Matthew just for a couple more minutes, because we've got Adiyami with a hand up. Adiyami, can we hear from you?
Hello, can you hear me?
Yes.
Okay. First thing, I'm of the opinion that the legislation on rape is wrong, because it said something about penetration, so that discriminates against a certain set of people, which I would have kind of like agree if someone else that couldn't penetrate committed the same offense. So there's discrimination against people that can penetrate. Having said that, right, I do believe that it's kind of like important for someone to be able to give consent to something that is a possibility that may affect his or her life differently to other people, because looking at around, no one will deliberately decide to get infected by Ebola, knowing very well that someone has Ebola and that person is bleeding. Everyone is going to move away. But having said that, it's not right to stigmatize any form of virus, because people tend to move away or look at them in certain way. Because if someone is sitting on a bus, for example, and you said that person has this virus, definitely everybody moves away. Just like at the start of the pandemic, if anyone coughs on the bus, the next thing you look around you, everywhere is clear.
Yeah.
And that person, yeah.
I understand. I think, Adami, my answer would be this, and then I'll hand over to Matthew. But my answer would be that that's precisely why I like to think about the difference between a public health response and a criminal justice response. That really what this debate is about is whether or not the state should intervene to create public health responses that, for example, can be through mask wearing in COVID-19, regulating people's behaviour about how far they can go out or who they can go out with and so forth. That's a public health response, sometimes with a criminal sanction. Whereas what we're talking about here is a criminal justice response that criminalises people for the passage of a virus. So I see your point with Ebola. The public health response would be education to ensure that you're not in a situation to catch something as horrendous as Ebola. Criminalize, I think that what you've said is
decided to go out and deliberately infect people. So
Matthew.
Yeah, I think you've covered it very well, actually. I've just noticed that Cameron's got his hand up, and I would like to hear Cameron's question for a reason.
I think that answers your question, Adami, that there's a difference between public health and criminal justice. Cameron, next. Thank you. I didn't see Cameron's hand. I'm sorry. Go ahead, Cameron.
Oh, no, that's fine. I think I stuck it up in the middle of the discussion there.
Sorry.
You mentioned consent apps, and I think some of those are particularly interesting. Some of the ones that we've seen in the US, where colleges have sent out messages along the lines of, well, you should be using this with all of your sexual partners. And really, it's a very broad question here, so feel free to take it off in whatever direction you fancy. But I'm wondering what your thoughts are around what they capture at that moment of consent, because some of them are ones where you've got to hold down and you've got to record you saying, I am consenting to having sexual activity with this partner. Some of them are linked in with social media accounts and things like that. And I'm wondering how much the sort of common sense approach that the courts have tried to take in cases like McNally really will come through if the courts are trying to look at evidence that's taken from sites like that.
I'll come up with a story in a moment, but I'd like Matthew to take that one first if you can.
I've talked to Cameron quite a lot today. I think it'd be very interesting for you to respond.
Okay, there we go. So, all right, congratulations on your Viva today, Cameron. I've heard about you. Brilliant, well done. We thought you might be halfway down a bottle of champagne by now, so you're very, very dedicated to your topic. I think here's the story. This is the story that I like. So one of the pieces of evidence in the Rowe trial was two guys, one Mr. Rowe, one the complainant. The complainant's on a train going into London. Mr. Rowe's texting him. They're having a text conversation. And they're talking about making soup, pumpkin soup. And the conversation is, well, can we see you again? When we see you again, we'll make some pumpkin soup. Where are you going to? Well, I'm going to London. Will you be going to this club? Apparently there's a club where you can go and you all have sex in a darkened room. And then there's a few jokes about going to that club. He wasn't going to the club. It's just jokes about going to the club. And then there's this, that the evidence was, if I did go there, I'd be able to get a pumpkin up my bottom, which was a joke. It was so obviously a joke to me. And when I cross-examined the witness, it was a joke he said, yeah, that was a joke. But the whole thing was read out by prosecuting counsel and prosecuting junior, playing the part of each person in the conversation, as though this was some horrendous form of conversation or some form of grooming, or it was so beyond what I could understand from that conversation, and beyond the understanding of both Mr. Rowe and the person in that conversation, that there was a prosecution narrative, very heteronormative prosecution narrative about a pumpkin. But what really worries me about these apps, and I'll tell you the story about the nail bar as well, because they're the ones that just demonstrate how the prosecutorial narrative against a background of a very traditional court of appeal common sense means that the interpretation of apps is going to be seriously problematic. That's my view. And we see it already in terrorism trials that I do. And very quickly, another example in a terrorism trial was my client had a picture of the Muslim equivalent of Joan of Arc. And that was said to be terrorist related material because she's on a horse with a sword and a burqa. I've printed it off. I'm going to put it on my wall because I thought she was marvelous and I didn't know about her. And does that mean if I have Joan of Arc on my wall that I'm problematic? Do you see? So I think that's my general view about applications and the use of text communications to provide low-level inferences that create enormous conclusions in relation to people's behaviour. And we haven't quite understood what prosecutors are doing properly with these types of applications. So there's a big move to produce such applications. Oh, let's spend loads of money producing those applications without thinking about how they're going to be used by prosecutors and infer what people must have known or must have been doing rather than what they were in fact doing and were in fact talking about, which frankly was making soup. So Matthew, I think that's what I think. Cameron, I'm not sure it entirely answered your question.
I have no gourd related anecdotes of any kind.
I've got an anecdote for everything.
Absolutely I'm going to have to go. Unfortunately,
I think we'll sign off. Thank you very much. Yes, thank you for the extra time. Thank you for everybody for your comments in the chat. I'm glad that we're taking sexual autonomy seriously, that we're worried about something as important as consent, that we've had people from frankly all over the world engaging in this, our concerns about PrEP and PEP. We will write this up as an article. It will come with slides, so please sign up for our Chambers newsletter. I think it's on the website. If not, it will be soon. In fact, Marie, thank you very much, has put the link to sign up in the chat, so you'll have all that information in some form of logical order from both Matthew and and I. So thank you very much indeed.
Yeah, and can I say thank you very much to everybody, to Sarah, to Felicity, to say hello to people I've never met before who participate. It's lovely, and a very particular hello to all of the people on here who I do know, and it's very nice to know that you were here. Some of you I haven't seen for well over a year or longer because of the circumstances.
I've been determined to get you on, so I'm very grateful that you came. For underneath my halo that I seem to have here in the room that I'm in, I shall say thank you so much, and I look forward to seeing you in person soon. Take care, everyone. Thank you for coming. Goodbye.
Bye.